Hi, my name is Lindsay Poirier. I'm an assistant professor of statistical and data sciences at Smith College, and my paper is called Accountable Data, the Politics and Pragmatics of Disclosure Datasets. So this paper attends specifically to what I call disclosure datasets, which are tabular datasets that aggregate information produced and reported by the same institutions they're meant to hold accountable. And the values reported in disclosure datasets can lead to adverse actions, either formal or informal, taken against the reporting institutions. And these issues institutionally incentivize misreporting and creative accounting. Examples of disclosure datasets in the US include the toxic release inventory, where industrial facilities report how much pollution they release, and police stop count data, where officers report the circumstances of an encounter with citizens. So this paper traces the socio-political provenance of disclosure dataset infrastructure. And specifically, it contributes to literature calling for critical inquiry into the genealogies of datasets, as well as literature calling for critical readings and ethnographies of datasets. And the analysis of disclosure datasets presented in this paper poses important questions regarding the representativeness and the usefulness of these accountability mechanisms. So I begin by briefly reviewing the methods I employed to study the socio-political provenance of 3 example disclosure datasets. I go on to introduce the datasets and identify 2 findings. First, that data definitions for disclosure datasets are malleable, and second, that the reporting forms infrastructure their recorded values in certain ways. I conclude with a call for further ethnographic research into disclosure dataset collection and infrastructure. Laws requiring corporations and governing bodies to disclose information about their practices have emerged alongside efforts to strengthen freedom of information laws and amidst growing public concern over environmental and corporate responsibility. And open data movements that sprang up throughout the United States and across the globe in the 2000s set the agenda for publishing government information as structured data sets. For this paper, I studied 3 disclosure data sets representing a diversity of domains where disclosure figures centrally. To do so, I studied data documentation published by the agencies that steward the data, seeking to invert the data infrastructure by examining the standards underlying the data's reporting and classification. I studied the genealogies of these standards by reviewing legislation where the standards were encoded into law, judicial cases where the standards were disputed and arbitrated, and news articles and commentaries where the standards were critiqued and debated. And for 2 case studies involving federal data sets, I reviewed hundreds of public comments submitted to the United States regulations.gov, a website supporting public participation in government rulemaking. In particular, I reviewed comments when notices of proposed changes to the data collection were posted. And it's worth noting that this data source presents its own biases. In recent attention has been drawn to swaths of fraudulent comments attributed to regulations.gov in response to controversial issues such as net neutrality and various environmental regulations. And while I considered this issue throughout the work, this leg of the work aimed not so much to measure public sentiments towards data reporting programs and more to document themes and controversies emerging around the programs. And these themes are particularly prevalent in cases when I suspected coordinated posting. So the first case study is the Environmental Protection Agency's Toxic Release Inventory, or TRI. The EPA's Emergency Planning and Community Right to Know Act of 1986 established the TRI to monitor and inform the public of toxic emissions released in their communities. And every year, certain US industrial facilities are required to report to the EPA the amounts of certain chemical on-site and on-site releases. Notably, while this act mandates reporting of emissions, it does not mandate monitoring of emissions. And while other environmental regulations do set certain monitoring standards for specific TRI chemicals and pollution activities, for all other chemicals and activities, facilities are required to report based on a reasonable estimate of the releases. And studies into TRI data quality have uncovered considerable resulting issues, often attributing them to the self-reported nature of the data. Reporting issues are sometimes referred to as phantom reductions, referring to cases when changes in emissions at large facilities have more to do with changes in estimation methods and interpretations of the law rather than actual reductions in emissions. The second case is the New York City stop, question, and frisk data set. Every time a New York City officer stops an individual based on reasonable suspicion that they committed or were about to commit a crime, the officer is required to fill out a form documenting information about the stop, including the reason for the stop, the demographics of the individual stopped, and any actions taken during the stop. And these reports get aggregated into a database that became available for public download in 2008. In the 1990s, in an effort to reduce crime in New York City, commanders began generating statistics to review policing effectiveness. And there were consequences associated with failing to demonstrate reductions in crime, and this institutionally incentivized data manipulation, an issue often referred to as juking the stats. Despite data quality issues, stop and frisk data indicated that by 2011, the number of stops had increased in New York City 700% from when data collection began in 2002. And the data was successfully leveraged to show that stop and frisk was being conducted in an unconstitutional way in the 2011 district court case, Floyd versus the City of New York. So the final example is the Home Mortgage Disclosure Act. Which I will describe briefly, but I don't talk about in the presentation. I do talk about it more in the paper. In order to ensure that financial institutions are in compliance with fair lending laws in the US, lenders are required to collect and report data on an applicant's ethnicity, race, gender, and income when they apply for a mortgage. And lenders are legally required to submit the information that applicants self-report when filling out a loan application. In cases when an applicant elects not to provide their demographic data, lenders are required to record based on visual observation of the applicant or the applicant's surname. And one investigation found that for over 3 years, loan officers at Freedom Mortgage, one of the top 10 lending institutions in the United States, were instructed to list non-Hispanic white as the race and ethnicity for every applicant that elected not to provide their demographic data. So the first finding of this paper discusses how social advocacy renders the definitions underpinning disclosure data sets as malleable or subject to continual ontological change in response to shifting cultural values and political power. And decades of scholarship in information studies and science and technology studies has shown that standard setting is animated by various cultural commitments and forms of political contestation. For disclosure data sets, definitional disputes tend to emerge around what counts as a reporting entity, along with what counts as a reportable activity. Typically, not every institution that engages in a certain business activity monitored by the government is required to disclose information through programs that generate disclosure data sets. Instead, only those institutions that meet certain criteria or meet a certain threshold of activity are required to report. And notably, disclosure data sets are often embroiled in big government versus small government debates, with small government proponents arguing that mandated reporting places an undue regulatory burden and costs on businesses, while others argue that reporting increases institutional accountability and transparency. Because of this, political debates often emerge over the definitions establishing reporting criteria and thresholds. So in 2006, under the George W. Bush administration, the TRI burden reduction rule was put into effect, aiming to reduce the time and resources needing to report information to a federal agency. This rule changed the definition of a TRI reporting facility by raising the threshold at which industrial facilities had to report managed waste of any non-persistent, bioaccumulative, and toxic or non-PBT chemical. And it raised the threshold from 500 to 5,000 pounds, given that no more than 2,000 pounds resulted in releases into the air, water, or soil. Facilities releasing non-PBT chemicals under this amount were permitted to fill out a simplified form that did not require a calculation of total emissions. And the rule was implemented despite extraordinary public comment opposing the changes. So a report from the OMB Watch documented that of the more than 100,000 public comments received, more than 99% opposed the changes. And comments opposing the changes were submitted by state agencies or attorney generals in 23 states, along with the EPA's Science Advisory Board. So with the TRI burden reduction rule, the total releases of chemicals reported in these years was lower than in previous years, not because fewer chemicals were being released, but because fewer releases were included in the total calculation. In 2009, when Obama was elected, the Omnibus Appropriations Act restored the thresholds for reporting back to their pre-2006 levels. So this case shows that while definitions change, not all stakeholders hold the same degree of power to mold definitions in new ways. And further, the malleability of disclosure dataset definitions is often a double-edged sword for advocacy groups. In one sense, their disputability of the definitions makes it possible to extend or revise reporting requirements. Yet when the definitions underlying disclosure datasets change, it becomes increasingly challenging to perform longitudinal analysis with the available data because the data becomes inconsistent over time. And this poses obstacles to tracking whether issues warranting public concern are being addressed over time, along with the effects of policy on business decisions and activities. So the second finding has to do with the forms that reporters fill out in the process of disclosure. So in all examples of disclosure datasets presented in this paper, reporters are required to submit their data by filling in a series of structured blanks in a form. And in the published datasets, the unit of observation, or what distinguishes one row of data from the next, is not a person, institution, or activity, but a document representing information about those people, institutions, and activities. And rarely do those filling out forms stop to consider the meaning and cultural rhetoric behind prompts and accompanying blanks. So Lisa Gittleman argues that forms tend to be seen as having users, but not as having authors. And their apparent objectivity hides their cultural histories. Yet forms quite literally form the resulting data, shaping them according to the form's flow and the form's structuration. So consider the New York City stop and frisk data. Whenever an officer stops an individual under reasonable suspicion that they committed or were about to commit a crime, they're supposed to fill out a UF-250 form, documenting information about the stop. And this form presents officers with a series of fill-in-the-blank text boxes for prompts such as time of stop, name of person stopped, age, weight, and build. And when New York City's stop and frisk practice went before the US District Court in 2011, a primary topic of concern was the checkboxes presented to officers on the reporting form under the heading, "What circumstances led to this stop?" In almost half of the forms submitted between 2004 and 2009, officers had checked the vaguely defined furtive movements box under this heading. And throughout the case, officers testified that furtive movements could indicate an individual walking a certain way, looking suspicious, or acting fidgety. And the ruling ultimately indicated that this category did not meet the legal criteria for justifying a stop, likely contributed to racial profiling, in order that the form itself be redesigned. The resulting changes to the reporting form are not documented within the dataset's data documentation. So like data definitions, forms are molded in line with and can evolve in the wake of certain political commitments and interests. They play a critical intermediary role in translating complex issues onto paper and eventually into databases, and their enumerability makes measurement possible even as their structuration reduces the complexity of what can be reported. So this paper highlighted dimensions of disclosure datasets deserving critical attention from data analysts and critics. For one, disclosure datasets narrate stories about discrimination and other forms of corporate and government wrongdoing, almost solely from the perspective of the institutions they're designed to monitor. Further, the values recorded in disclosure datasets are not neutral, but instead rhetorically shaped, as their underlying definitions and data collection tools evolve in the face of political advocacy, contention, and power. And while disclosure datasets have historically served an important role in US civic life, the lack of attention to their social and political provenance at times poses challenges to mobilizing the data effectively. Presented without context, powerful actors can celebrate disclosure datasets as advancing quantitative, evidence-based approaches to institutional accountability when it serves their interests, and then blame special interest politics for tainting the objectivity when it doesn't. And the lack of attention to the provenance of these datasets renders the social actors that have shaped the programs invisible, along with the historical and future role of social advocacy in strengthening them. And this demonstrates the need for further ethnographic attention into the creation, maintenance, evolution, and interpretation of disclosure data sets. So thank you so much for tuning in, and I'm happy to take any questions as they arise.